We'll get started here in a moment after everyone's been able to enter the webinar. We'll give it another couple of seconds. I still see people joining. Okay, welcome everybody to the Dykema Drives webinar series. My name is Cody Rocky. I am a partner in the antitrust practice here at Dykema. I handle antitrust litigation, regulatory matters, and compliance counseling for clients in a variety of industries, including in the automotive industry. And I work out of Dykema's Ann Arbor, Michigan office. Before we dive in here, just a reminder that today's presentation qualifies for CLE credits. You'll receive a copy of the slides from today's presentation after the webinar concludes, and that will include information about how to claim the CLE credits. Today's webinar is the sixth in a series of webinars based on Dykema's 2024 Automotive Trends Report. This report is a compilation of the most pressing legal issues identified by executives and in-house counsel in the automotive industry. You can find a copy of this report at the QR code that you can see on your screen, and it'll be in the slide deck when you receive that. If you have not had a chance to review it, you can take that opportunity to take a look. Today with me, I have three of my colleagues from here at Dykema that will be presenting. Along with myself, Howard Irie practices in the antitrust group here at Dykema. He is based in Dykema's Bloomfield Hills, Michigan office. He has years of experience guiding clients in the automotive industry through antitrust litigation and providing them with antitrust compliance counseling. Also with Howard and I is our colleague Darren Wade. He is one of the leaders of Dykema's product liability and class action practice group. He is based in Dykema's Dallas office. He is an experienced trial lawyer whose practice focuses on defending automotive clients in product liability and catastrophic injury cases. Joining Darren for their half of the presentation will be Brad Howell. He is a leading trial attorney who practices out of Dykema's Houston office. He too focuses on defending clients in product liability and catastrophic injury cases, including clients in the construction machinery space. As you can see from today's presenters, Dykema has several attorneys across its footprint who service clients in the automotive industry. Based on the capabilities here at Dykema, we are able to service clients in this industry from coast to coast, as you can see on the slide in front of you. With that, I would like to turn to the first of our two topics for today's presentation. Howard and I will be presenting on a couple of the antitrust issues that were identified as pressing issues in the 2024 Automotive Trends Report that I previously discussed. I will be talking about antitrust issues in AI, and Howard will be discussing antitrust issues intersecting with the right to repair movement. In the AI space, the most prominent current issues related to antitrust law concern the common use of pricing algorithms by competitors. But before I jump in to that specific issue, I thought it might be helpful to sort of set the table with a reminder of what the antitrust laws cover that are relevant to this issue. In particular, Section 1 of the Sherman Act prohibits collusion. That covers what is commonly considered agreements that unreasonably restrain trade. What constitutes an agreement is anything that could be considered a conscious commitment to a common scheme or course of action. This is more than something you might consider an agreement that forms a contract. It can be expressed, it can be implied, it can be verbal, it can be what some think of as gentleman's agreement. One Seventh Circuit case even referred to it as nothing more than a wink and a nod between two individuals. Certain types of agreements are per se illegal under the antitrust laws. This includes price fixing, bid rigging, and allocating business. That could be allocating customers or allocating territories between competitors. Other agreements that don't fit into this per se illegal bucket are evaluated for reasonableness, which requires showing that the conduct causes anti-competitive effects like higher prices or lower quality products, and that those anti-competitive effects are not offset by any pro-competitive benefits of the conduct. The type of agreements that falls into this bucket often includes vertical agreements. That could be agreements between a customer and its supplier. Of note here in the per se category, which is a lot of what we're going to be talking about in these AI cases that have sort of come to the forefront here recently. It's important to note that price fixing can take many forms, including setting a specific price, agreeing to hold the price or stick to certain minimum prices. It can also include agreements to use specific formulas to set prices. And in these kind of cases of note, there's often not a smoking gun, direct evidence like a communication or a phone call showing that two competitors agreed to fix prices. So instead, the government agencies or the private plaintiffs often look to conduct from which they could infer that an agreement was reached. So for example, they might say, we see that they talked about pricing a certain way. And even though we may not know that they agreed to do it, we then see they subsequently acted in conformity with those conversations. We'll also see arguments in this space that say, look, they acted a certain way, and I don't think they would have done that unless they had an understanding with their competitors about how they were going to price, for example. And of note here, as we'll see when we talk about how this can intersect with AI, oftentimes plaintiffs will point to an exchange of competitively sensitive information between competitors. Think exchanging pricing plans between competitors. And they'll say, there's no reason they would have done that if they didn't have an agreement that they were going to, price the same or use the same sort of formulas to ultimately set their prices. And so oftentimes in price fixing cases, you'll see a focus on exchanges of information. Agreements to exchange information alone don't fall into the per se bucket that we've been talking about. Rather, those would be evaluated for reasonableness. Does the exchange of information cause an anti-competitive effect? But remember, the existence of information exchanges can be used by plaintiffs or government regulators to argue that, in fact, there was an illegal price fixing agreement and that the exchange of information was just part of facilitating that. So as you'll see in these cases, the exchange of information is often a focus of the case. So with that sort of background on what Section 1 of the Sherman Act prohibits, let's think a bit about how this might intersect with AI. And to demonstrate this intersection, we actually went to ChatGPT and asked how AI could help set prices. And this is sort of an excerpt of the response that we received. And these were 10 different ways that AI says it could help you in setting prices. You'll see things like it can help you monitor competitors' prices. It can help you develop a pricing strategy that can optimize revenue or profits, or it could help do things like forecast demand. All of these things could implicate antitrust law, the type of issues we were just discussing around price fixing or anti-competitive effects flowing from information sharing. Of particular note, AI also reminded us that it's not a lawyer. and says that it's crucial to ensure that your pricing strategies align with legal and ethical guidelines. And this really gets to uh, one of the takeaways from this part of the webinar today, which is if your business is using AI in a manner that relates to how it competes, like price setting, it's really important to make sure you've done your diligence on whatever AI tool is being used to make sure that its use doesn't expose your company or your client to antitrust risk. How might it expose you to antitrust risk? I find this quote from the then FTC acting chairman Olhausen from 2017, showing this predates sort of the current uptick in the use of AI, as a good example of how to think about how AI could implicate antitrust laws. And basically, I'm not going to read the quote here, but basically what Chairman Olhausen was saying is, if you think about the use of AI or an algorithm for price setting to be no different than hiring a guy named Bob, you'll start to see how this might implicate the antitrust laws. In particular, if competitors are using the same AI, or if they're all hiring a guy named Bob, and they're all giving their competitively sensitive data, whether it be pricing plans, strategies, current capacities, input costs, to Bob, and then Bob is using that to tell all of them how to optimize their pricing, it's not hard to see how this could result in price fixing among that group of competitors that's using a common tool. In fact, it's not hard to see how that could result in the group setting prices as if they were a single company, a monopolist, for example. So when it comes to considering using AI in some competitively sensitive manner, these are some important questions to ask yourself. And we're going to see how some of this plays out in some of the example cases I'm going to talk about that have raised these issues. If you have competitors using the same algorithms, it's important to understand what data is being used. Is it your data? Is it others' data? What is the source of that? Is it private data? Was it already public? All of these can play into analyzing the antitrust issues that come about from using this AI tool. What is the AI doing? Is it telling you what price to set? Do you have systems in place that automatically accept those decisions by the tool, or is it just a recommendation, one piece of data that decision makers are using when deciding how to set prices, for example? Is the tool, the algorithm, available to customers, not just to the sellers? Are the competitors encouraging each other to use the software? That could play a role into the analysis of whether there's any sort of anti-competitive agreement from the collective use of the same software. Are there suggestions that the software will be used only to raise prices? All of these things have played a role in the cases that I'm going to talk about here momentarily, and are things that plaintiffs or regulators have picked up on when they've challenged sort of collective use by competitors of AI. So let's talk about how this has come to light in some recent litigation and enforcement actions. There were two cases pending in Nevada and New Jersey, respectively, against large casinos and hotel operators. They were all allegedly using software that recommended the price they should charge for their rooms. The software touted its ability to monitor competitors' prices, offer forecasts of demand, and also highlighted that it was using both public and private data in providing its recommendation. Private plaintiffs brought two suits in each of these areas. After motion practices in both, the defendants were successful in defeating the antitrust claims in these cases. In particular, the court noted that the plaintiffs had been unable to allege that the hotels had agreed amongst each other that they would all use this common software. So there was no agreement in this instance to set your prices with a common formula. In addition, there were no allegations that one company's private data was being used to make the recommendations that another company should set its prices at. This goes really to that information sharing point I was talking about. In this case, while individuals were giving their private data to the software, it remained possible that the software was simply taking that private data along with public data about competitors and using that to make a recommendation. In that way, the court said, you haven't even really alleged that these parties are sharing private, competitively sensitive data amongst each other, or that the software is using that data to make recommendations to anybody else. They went through a couple of rounds of motion practice in the Nevada case. It was ultimately dismissed with prejudice, and the New Jersey case met the same fate just recently here at the end of September. A similar case remains pending in Washington against a company that provides similar pricing recommendation software to companies who manage rental properties. The allegations in that case are that the software uses data from all the companies, that is private data from all of the companies, to recommend rent that each one of them should charge. Plaintiffs often allege in these cases that the software is actually alleging that some of these landlords would find it better not to rent all their properties and to instead hold some back in order to charge higher prices for those that they're actually going to rent. That's sort of a hallmark of what courts consider to be anti-competitive effects. Plaintiffs here allege both per se and rule of reason claims. They allege that the landlords actually agreed to fix prices, reduce output, and fix prices. And they also allege rule of reason claims. That is, even if there wasn't an express agreement to collectively use the software or to collectively accept its recommendations, the mere fact that they've all given their private data to the software and know that it's going to be used to give recommendations to competitors amounts to a rule of reason claims. Motions to dismiss are pending in this case with oral argument set for next month. Perhaps one of the most high-profile cases in this space right now is the RealPage case. The private lawsuit is pending in Tennessee right now. This is similar to the case I just talked about, although it involves student housing rentals and multifamily rentals. These are buildings with 5 or more apartments in them. Like the prior case, the software allegedly uses non-public data from all the participants to recommend rent. Again, in some instances, recommending that you don't rent all of your apartments, rather you hold some back to reduce supply and raise prices. The allegations in this case include that the software provider pushes parties to accept its recommendations and sort of touts that as one of the benefits of the service that it provides. In this instance, the court has ruled on a motion to dismiss. And while it's not letting some claims go forward, it is letting others go forward, and this litigation is ongoing. It did find that plaintiffs had alleged a conspiracy to exchange private, competitively sensitive data, but it rejected per se claims, finding there weren't allegations or not sufficient allegations that the competitors had agreed to follow the recommended rents provided by the software. So it sort of rejected the price fixing claim in the case. It said the information exchange claim could go forward, but only as to the multifamily housing, because their plaintiffs had alleged sort of geographically local markets and said enough competitors were using the software in those markets that exchanging the data could have the effect of raising prices. In contrast, it rejected the student housing claim because their plaintiffs had alleged a national market, and the court said that's implausible. And without local markets and enough users in the market to cause an anti-competitive effect, it wasn't going to let the claims go forward. Of note here, this is an example of where the government regulators have stepped in. The Justice Department has sued RealPage, essentially based on the same allegations that are pending in the private litigation. It's focused on the rule of reason claim, that is just the information exchange claims, and not taking on the extra burden of trying to prove that the parties had actually fixed prices. So those are some examples of where AI is intersecting with antitrust. And the key takeaway, again, in this section is that it's important to vet antitrust tools that your businesses are using to make sure they don't increase antitrust risk. And these are some of the important questions that I previously identified to be asking. What data is being used, how it's being used, what is the software doing for the various companies that are using it. These will be important questions to analyze in this area. I'll note also that this is part of a broader push by government regulators to sort of discourage sharing of information that they believe causes anti-competitive effects. They have a number of cases pending in this space, and there are other private cases that don't necessarily involve algorithms, but involve information sharing in the insurance industry and in the luxury hotel industry that are pending. And with that, I'm going to turn it over to Howard, who will talk about sort of another hot topic in antitrust these days, that is the intersection of antitrust and the right to repair movement. Howard?
Thank you, Cody. Good afternoon, everyone. Let me give a little bit of history of the so-called right to repair movement. It's been percolating for a few years, but a pivotal event happened in 2021 when President Biden rolled out the omnibus executive order for a whole of government approach to promote competition in a number of sectors of our economy. The order highlighted a number of areas, including the repair market. At around the same time, the FTC was investigating the impact of manufacturers' restriction on repairs, and the commission issued the Nixing the Fix report to Congress in May of 2021. And just a few days after the executive order, the FTC issued a policy statement on repair market restrictions, proclaiming that it will prioritize enforcement in the repair market under both the consumer protection and the antitrust laws. This policy statement incidentally had unanimous support from the commission's Democrat and Republican commissioners. Now, the FTC did follow up on this. In early 2022, they sent out warning letters and eventually entered into consent decrees with Westinghouse, Weber Grills, and Harley-Davidson. The commission alleged that their warranties violated the Magnuson-Moss Warranty Act and Section 5 of the FTC Act because they potentially conveyed to consumers the message that the use of non-branded parts would void factory warranties. Each of these companies entered into consent decrees. They didn't admit liability, but they nonetheless agreed to change their warranties and provide notice to dealers and customers that using aftermarket parts alone would not void OEM warranties. These three actions also were unanimously approved by all the 5 FTC commissioners. And last July, the FTC sent out warning letters to another 8 companies. The warning letters expressed the FTC staff concern that 5 of these companies represented to consumers that they must purchase their own branded parts to keep the warranties valid. And 3 of these companies placed stickers on strategic parts of their products that said warranty void if removed. And we can't forget about the states. I won't go into detail, but 5 already have existing right to repair laws in a number of specific industries. 30 more have debated the right to repair legislation. And there's also been a few bills proposed at the federal level, including the Repair Act, which covers the automotive industry. These bills were not voted on in the present Congress, but they may be introduced last year. And to no one's surprise, the antitrust class action bar has jumped on the right to repair bandwagon. 2 early noteworthy cases were antitrust actions. One was filed against John Deere. The plaintiffs alleged that Deere designed certain of its equipment to require Deere software and tools to make repairs, and also limited the ability of independent repair shops to access these software and tools. Plaintiffs claimed that Deere used its monopoly power in the tractor and combine market to harm the parts and service market, resulting in higher prices for repairs and services. They also included a claim that Deere conspired with its dealers to carry out this scheme. The court denied the motion for judgment on the pleadings, and this case is still pending today. The Tesla antitrust case was similar. It claimed that Tesla used its monopoly power in the EV market to harm the parts market and conspired with its parts suppliers to carry out this scheme. Like in the Deere case, the challenge practices included designing the Tesla EVs to require Tesla software and tools for the repairs and limiting the independent dealers' access to these parts, service, and software tools. A few other practices were also alleged in Tesla, including one of which is kind of my favorite, using geofencing technology to only permit repairs if a car is within the vicinity of a Tesla dealer. Some of the other practices alleged were they designed vehicles with non-standard parts and included statements in the warranty that discouraged use of independent shops and aftermarket parts. The court recently denied a motion to dismiss the amended complaint, and the case is pending today. Finally, the third noteworthy case in the right to repair area was against Harley-Davidson. Dykema happened to defend Harley-Davidson in this case. It involved a 90-count complaint that not only included antitrust tying and monopoly claims, but also various state law consumer protection and fraud claims, and a claim for violating the federal Magnuson-Moss Warranty Act. On this page, you'll see the particular warranty provisions that plaintiffs challenged, and you can review these at your leisure. Now, like the other cases, the antitrust claims here were that Harley leveraged its alleged market power in the motorcycle market, specifically the American-made large road-going motorcycle markets, to harm competition in the parts market and thereby overcharge consumers for parts. The plaintiffs specifically argued that the risk of voiding a factory warranty associated with the purchase of non-Harley parts made it too costly to buy non-Harley-Davidson aftermarket parts during the 2-year warranty period. According to plaintiffs, this created a tie of the Harley-Davidson motorcycles to the purchase of Harley-Davidson parts. We filed a motion to dismiss on all counts, and we're happy to say it was granted by the district court, and this case is now on appeal to the Seventh Circuit. The court first ruled that there was no explicit requirement to buy Harley-Davidson branded parts in order to purchase a motorcycle. The court next rejected the notion that the warranty terms here implicitly force consumers to buy Harley-Davidson parts. As we argued, even if the court assumes that buying aftermarket parts would in fact void the warranty, and that's not what the warranty said, the class didn't plausibly allege facts showing that foregoing some or all warranty coverage to buy an aftermarket part was so costly that consumers were economically forced to buy only Harley-Davidson parts. The court recognized that the OEMs obviously have to place limits on what they're willing to warrant, and the court also relied on cases rejecting tying claims if consumers could themselves forego warranty coverage if they wanted to buy an aftermarket part. We presented several other grounds for dismissal that the court didn't need to reach because they found that there was no tie. For example, we argued that the so-called American-made large road-going motorcycle parts was somewhat gerrymandered to gin up the argument that Harley somehow had market power in the tying product market. Complaint, in fact, alleged that Harley-Davidson faced competition from Japanese and German manufacturers of motorcycles. We also successfully deflected the impact of the FTC consent decree that I mentioned a few minutes back. We pointed out that Harley did not admit liability in the consent decree, and that an untested FTC complaint alone was not determinative of anything. Did this argument work? I think so, because the court didn't even mention the FTC consent decree in the opinion. And here you see the court's findings on the rejection of the Magnuson-Moss Warranty Act claim, namely that the warranty did not say that use of non-Harley Davidson parts would void the warranty, and that knows even an unsophisticated consumer would not understand the word may to mean will void. The warranty also didn't omit any relevant terms, and there was no allegations that Harley Davidson failed to include a warranty with each motorcycle sold. Court also rejected the fraud claims, finding that plaintiffs never really alleged what Harley misrepresented, omitted. And in fact, they alleged in one point of the complaint that Harley Davidson told consumers that they had to use Harley Davidson parts, and at another point that they failed to disclose. So with that, I would turn the mic over to my product liability trial colleagues. So I appreciate it. And Brad Howell, it's yours. The microphone is yours.
Thanks, Howard. Appreciate it. Ladies and gentlemen, good afternoon. Thank you so much for joining us. As Cody mentioned earlier, I'm a trial lawyer in Dykema's Houston office. I'm going to be tag teaming this presentation today with my partner, Darren Wade, who's a trial lawyer in the firm's Dallas office. This afternoon, Darren and I will talk about risk in litigation. Litigation is risky for a number of reasons, but it's now riskier than ever for one primary reason, and that reason is damages. We all know that trials are inherently unpredictable. I don't recall a case in which I've been involved where the result didn't turn on something unexpected happening during trial, whether it be witness testimony or a judge's ruling, and the list goes on and on. But litigation is different nowadays because defendants have to worry about the specter of what's come to be known as the nuclear verdict. Nuclear verdicts are defined in one of three ways. They're awards in excess of $10 million, or they could be non-economic damages that aren't proportional to the economic damages. And then third, an award less than $10 million, but substantially more than expected. Think the McDonald's coffee case verdict. According to the U.S. Chamber of Commerce Institute for Legal Reform, we'll call that the ILR, there's even a classification of nuclear verdicts in excess of $100 million. These are known somewhat uncreatively as mega nuclear verdicts. The ILR determined the following based on a study of 1,300 personal injury nuclear verdicts between 2010 and 2019. One, the amount of nuclear verdicts is increasing both in the amount and the frequency. Almost 1/3 were between $20 million and $50 million. And third, approximately 16% exceeded $50 million, including about 100 mega verdicts. Almost 70% of personal injury nuclear verdicts are rendered in these three categories of cases: product liability, auto accidents, and medical liability, with product liability litigation leading the way.
So Brad, could we stop on that one just for a moment?
Absolutely.
I don't know if you want to go back. There you go. Thanks. So I mean, it's no great surprise that because of the nature of you have large corporate defendants in product liability cases, whether that's Caterpillar, Toyota, General Motors. Typically, it's a larger entity as opposed to like an auto accident. And I frankly found this statistic, kind of, interesting and a little bit bewildering, because you've got auto accident at 23%. And, if that's just, car A hits car B, what is the insurance that car A has? It's there are steps you have to go through to have a $100,000 case, then end up with the sort of nuclear verdicts that we're talking about here. Products is a little bit different because the nature of the injuries that you're usually dealing with, and with a corporate defendant, that's not, there's not a policy in the same way that there would be for a liability policy for a driver. So I found those two things to be somewhat interesting about the statistics. Not super surprising, but an interesting sort of breakdown.
Yeah, it's good observations, Darren. And kind of further to that point, statistics show that the median verdicts over a 10-year period were about 21 million. So as nuclear verdicts go somewhat low, however, the ILR reported that the mean nuclear verdicts is on the rise. So from 2010 to 2019, they were showing $76 million for an average, but from 2013 to 2022, including those three later years, the mean verdicts rose approximately $15 million to 89 million. And Darren, again, to your point, one of the most startling statistics on this slide, according to the ILR, is the mean verdict for product liability litigation is close to $216 million. So kind of a frightening statistic there.
That's an eye-opening number, right?
It is indeed. So if you're wondering, ladies and gentlemen, if a nuclear verdict is likely to happen where you live and work, these are the states in which they are most common. We've got California, Texas, Pennsylvania, Illinois, New York, and Florida. And the ILR identified some, quote, honorable mention states as Georgia, New Jersey, Washington State, and Missouri.
So let me add a couple of comments on this one, Brad. So interestingly, I mean, I sort of intuitively thought this was right, and I checked it to make sure. Those are the 6 most populous states in the country. In ranking order: California, over 30 million, Texas over 30, followed by Florida, New York, Pennsylvania, and then Illinois in 6th place. And what's sort of interesting is, each of those states has large urban areas, just picking Texas as an example, Dallas, Houston, Austin with Travis County, San Antonio with Bexar County, where you have predominantly Democratic local governance, but you also have at the state level, a much more prominent Republican majority. Florida is the same way. When you look at how does that affect, litigation in those states, you still get with, large verdicts out of the larger urban areas in particular across the board. I don't think there's any big difference between a verdict in Dallas or Houston versus one in Philadelphia, for example, except for maybe, a few zeros, depending on if it's a roundup verdict from Pennsylvania. But what you do see is tort reform. And so one of the slides coming up, we'll talk about, regulatory and judicial or legislative sort of safeguards. You do see that in Texas. And in particular, you see it in Florida, most recently in 2023 when they passed House Bill H37, which was a pretty significant, comprehensive tort reform for the state of Florida. Negligence cause of actions, the statute of limitations went from 4 years to 2 years. You went from being a pure comparative fault state, where if you were a plaintiff, you could still recover, even if you were 95% at fault, to a bar where if you are greater than 50% now as a plaintiff in Florida and you're responsible for the accident or your injuries, you're completely barred, which brings that much more in line with the schematic approach to fault that Texas has had for 20-something years now. And damages also in Florida went from being the incurred amount to the paid amount, also bringing it somewhat more into the mainstream with more conservatively governed states. But if you look at California, Pennsylvania, Illinois, New York, you don't see that same type of legislative activity at the state level, trying to provide some sort of safeguards or boundaries, whether that's in the area of damages or liability reform, et cetera.
Yeah. Thanks, Darren. So I couldn't resist throwing in this slide, since you and I are both from Texas, but we've all heard the saying, everything's bigger in Texas, including jury verdicts. 2022, Dallas jury awarded more than $7 billion with a B to the family of an elderly woman murdered by an off-duty cable repairman. 2023, a Houston jury awarded $1.2 billion in a revenge porn lawsuit. And then 2023, again in Dallas, a jury awarded $880 million to the family of a woman killed when a crane collapsed into her apartment. Granted, these are outliers, but still serve as startling illustrations of what juries are capable of doing. Darren, to your point about judicial safeguards and limitations, these mega verdicts are often remitted by trial courts or thrown out altogether. by appellate courts, but not all of them. Going back to the $7 billion verdict up in Dallas, I believe it ultimately resulted in a judgment in excess of $1 billion.
Yeah, and the thing that's notable about, each of those is, in the Dallas off-duty cable repairman, the Spectrum verdict, the court let in a host of other incidents that created, if the case was going to, go up on appeal, an interesting appellate record for the Dallas Court of Appeals to decide. But there were significant, very aggravating, inflaming sorts of facts that were allowed into evidence that led to, you could draw a line between those facts and the verdict that's rendered. What's shocking to me as much as anything else is the one at the bottom, $880 million for a single wrongful death case. That is an astounding number. And, and what you don't see here, and what ultimately, takes place in the majority of these, is that while, the appeal is pending, there are negotiations and ultimately resolutions for most of these types of verdicts. But you have a factor where those numbers then become inflated because the top line judgment that's going to the Court of Appeals is also a much larger number.
Yeah. So some reasons for what we'll call radioactivity for these nuclear verdicts. We've all heard of reptile theory. So this is a tactic used by plaintiff lawyers to appeal to the jury's emotions. It focuses on safety and security of the community, suggesting to the jury that the community will be endangered unless a defendant is punished with a large verdict like this. We've also seen tactics known as anchoring, which is the use of arbitrary formulas or objects to justify massive awards. Think priceless works of art or jet airplanes, where the plaintiff lawyer says, well, if that costs $100 million, certainly the life of Mr. Smith is going to be worth much, much more than that. And just generally speaking, plaintiff attorneys are simply asking for bigger rewards. It's just the state of where we are in civil litigation. It wasn't that long ago in the practice that, in my experience anyway, plaintiff lawyers were somewhat reluctant to ask for big nuclear type awards, fearing that they'd lose credibility with the jury. And this is no longer true. I recently did a jury focus group, catastrophic personal injury case, and I was on the plaintiff side of that. I asked for a high 9-figure award simply to test whether the participants would be offended by that ask. And while they might not have agreed with it, very few faulted me or criticized the plaintiff for making that demand.
Two comments I would add on to that, Brad, and one of them is kind of just where you finished. Certainly the trend is to ask for higher numbers. And one way of trying to get there, if you're the plaintiff attorney and you've got significant intangible sort of damages that are non-economic, is you see more and more plaintiff attorneys just not submitting at all their economic damages. So, to the point of anchoring as a way of trying to have a larger verdict, we see plaintiff attorneys also cutting the anchor and getting rid of their economic damages case and going solely on non-economic, more subjective types of damages, which creates an issue on appeal too, certainly in Texas, where there is at least some case law in the form of the Gregory versus Chohan case from the Texas Supreme Court, a concurrence opinion from Justice Schenck that basically is offering the idea that when you are looking at rationales for the relationship between economic damages and non-economic damages, it's got to have some reasonable relation. That's at a high level. Well, if you get rid of the economic damages, then you have untethered sort of non-economic damages, and it begs the question of how courts or legislatures are ultimately going to be able to try to put some sort of boundary for what the top end of those awards could be.
Right. So that is the risk, damages, specifically the nuclear verdict. So Darren and I are now going to talk about strategies for how we might be able to avoid those nuclear verdicts.
Absolutely. All right, so I'll take the baton on the slides.
Okay.
And so in preparing for our presentation today, one of the things that Brad and I spent most time talking about is, we can, obviously sit here and tell you about what verdicts have occurred and, how did they get there and what are some of the considerations. But the more relevant thing at the end of the day for you as an audience and someone who is interested in these topics, especially if you're on the defense side or you work for a company that is frequently a defendant, is how do I avoid having my name in somebody's PowerPoint 2 years from now referencing my case because the numbers are so large. And from our perspective, we believe that process starts at the very beginning in trying to identify when a new lawsuit arrives, does it have particular characteristics or earmarks that might lend to a much larger type of verdict and exposure if the case is ultimately tried. And so that can be venue and jurisdictional considerations. It could be a particularly bad set of facts. I had a case from 2022, 2023, an explosion case with burn injuries that had particularly egregious spoliation of evidence facts that were not going to go away. And to Brad's point a moment ago, when you are doing a focus group, and we'll talk about that more in a moment, it's really important to test those things, in particular your bad facts, to see what sort of result that you get. I mean, that's what the data that you're paying for is how do people in this particular community or venue react to the set of facts that a jury in that jurisdiction might also see. And then the other thing you want to look for as much as possible is, are there legal defenses or areas for mitigation of damages that can help lower what the top end exposure might look like. So then the other thing that I think that significantly changed in the last 5 years, if you've walked into a courtroom and tried a case, ordinarily you would have 10 or 15 years ago, 1 or 2 defense counsel, paralegal, client representative, maybe an appellate lawyer, depending on the circumstances, if there's a particular argument that's an appellate lawyer is important to make. When you walk into a courtroom now, both on the defense side and particularly on the plaintiff side, you see 6 or 8 lawyers, including appellate lawyers, lawyers who have handled briefing, and basically additional associate or younger lawyers there in support of the partners or the more senior lawyers that are trying the case. We previously wanted to avoid kind of the disproportionate appearance of having too many defense lawyers to create or avoid creating the image that, it's a full team of defense counsel against, a single plaintiff attorney and his paralegal. I think those days, for the most part, Brad, are long since gone, at least for larger exposure cases. What do you see in your practice?
Absolutely. Just recently, Dykema tried a very large product liability case here in Houston, and I observed a good bit of that trial. And one of the things that struck me was the parity in size of the plaintiff's team versus the defendant's team. Again, it was always a concern representing corporate defendants that we don't want to look like we're the big bad corporation beating up on the little guy. Because cases, the stakes are so high, the plaintiff lawyers have their own teams. So that should definitely be an incentive for a defendant to make sure that the right team is in place when they go in, especially when you have this chance of a nuclear verdict.
And if you have cases, especially in the product liability space, where you have 6 or 8 experts, and in particular, if you're in federal court, you want to be deciding early on in the case and doing so with the input and guidance of in-house counsel. Who's the team that you're going to have to support you in research writing, your Daubert motions to assist in witness prep, the conduct of expert depositions, defending and cross-examining, and then any other motion practice. You don't want to get to 60 days before trial, and then all of a sudden say, you know what, we need, a bigger horse. That's not, you're not in nearly as advantageous a position if you build your team and make sure you have your resources in place much earlier on in the development of the case, and in particular, embedded appellate counsel. We won't turn this into a discussion about that, but most people are familiar with the concept. It is, having done that a couple of times this year, it is exceedingly beneficial to have appellate counsel as part of the trial team throughout the process, so that for critical arguments, hearings early in the morning or late in the day outside the presence of the jury, you as trial counsel can be getting ready for the next day while your appellate colleague is protecting the record and also making sure that the best foot is put forward on the client's behalf in arguments before the court.
And Darren, if I could jump in, I would also say that jury consultation and trial graphics is becoming a norm. It used to be a luxury to bring a trial graphics representative to help run PowerPoints or publish exhibits. I think nowadays it's almost essential. Juries expect to be entertained. I mean, they see a lawsuit on TV that gets resolved in 47 minutes, not including commercials. So it's no longer good enough to put a witness on the stand and write a few notes on a big chief tablet. In order to keep the jury's attention, you need to routinely publish exhibits and demonstrative aids throughout the duration of the trial.
100% agree. Absolutely. All right. In the interest of trying to stay somewhat on track, we'll move forward. Now, we've talked about the legislative and judicial safeguards. And of course, plaintiffs will argue around some of those. I'm going to go ahead and advance us to federal court as a generally preferred venue. And Brad's going to walk you through kind of what are the key things to consider there, and then also a discussion on SNAP removal.
Yeah, thanks, Darren. I think that suffice it to say, federal court is generally better for the reasons that we note on this slide. I think judges are more inclined to enforce rules and deadlines. Jury pools are better. Generally, nuclear and mega verdicts are less common, at least with personal injury lawsuits. Obviously, we have those big verdicts, but they're usually reserved for larger commercial cases like class actions, antitrust, patent litigation, and things of that sort. So if federal court is a better place to be, how do we get there? There's generally two bases, and this could be a whole webinar unto itself, but I'll try to get through it as efficiently as possible. There's basically two bases for federal jurisdiction. You've got federal questions, or you've got diversity of citizenship. Diversity citizenship is the most common basis, and that simply means that the parties on one side of a case must not be citizens of the same state in which the opposing party is a citizen. As an example, if the defendant is a citizen of Delaware and the plaintiff is a citizen of Texas, the parties are diverse. If they're both citizens of Texas, for example, diversity does not exist. Also, in order to have federal jurisdiction, and this is key to the issue of SNAP removal, a defendant must not be a citizen of the state in which the action is pending. So what is SNAP removal? It's a procedure by which a defendant removes a case to federal court before an in-state defendant has been served. Quick example, your client's incorporated in Delaware and has a principal office in Texas. Therefore, it's considered a citizen of both Delaware and Texas. The plaintiff is a citizen of Oklahoma. Therefore, the parties are diverse because the defendant is not a citizen of the same state in which the opponent is a citizen in Oklahoma. The plaintiff elects to file the lawsuit in Texas based on the defendant's principal place of business. Thanks, Darren. I forgot to move us along. The in-state forum defendant, back up. Since the client is a citizen of the state where the action is pending, it is considered a forum defendant. Therefore, according to USC 1441B2, federal courts have no jurisdiction. However, if you can file removal papers before the client, the in-state forum defendant, is served, then you don't consider the citizenship of the forum defendant for purposes of removal. That's called SNAP removal. This can dramatically affect the trajectory, valuation, and outcome of a lawsuit. I did this for the first time in a $15 million property damage lawsuit pending in a well-known judicial hellhole in Texas state court. After years of litigation, the federal judge granted summary judgment and the judgment was affirmed on appeal to the Fifth Circuit Court of Appeals. So considering how juries are currently valuing cases in these nuclear verdicts, your legal team must be fluent in this federal practice. It can literally save the client millions of dollars. So again, once you put together your team, as Darren discussed, and your lawsuit's firmly in place, whether in state or federal court, it's imperative to take steps to thoroughly understand its potential value. Don't leave this important consideration to chance or speculation. And one way to do this, of course, is through mock trials and focus groups.
Presuming everybody understands the distinction between a full-blown mock trial, which can take 2 or 3 days, and a jury focus group, Brad and I are going to share some thoughts with you about that. The key thing that I think that you want to bear in mind at the outset is, what are you trying to test? Are you trying to test damages? Are you trying to determine what is, a representative potential jury panel? What do they think of your particular facts? And then you structure both the plaintiff presentation and the defense presentation to make sure that the evidence in a 70 to 90-minute sort of clopening presentation by each side, that it's presented in such a way that the jury is left with kind of both sides of a particular issue, so that then when they go back to deliberate and complete the jury form on those particular things that you want to make sure you're getting your qualitative data out of. What sort of numbers do you get from them if they get to that end of the verdict form, as well as what their comments are as they go through deliberations on those key things. You've got to make sure that the presentations are structured in a way to accomplish that. Brad, anything that you would add that y'all do to try to make sure that you're getting the most value out of the client's money when you undertake these exercises?
Absolutely, Darren. And reasonable minds can differ. I know some lawyers prefer mock trials. I find those to be a little bit difficult to put on simply because you need to truly mock a case, you need witnesses. Sometimes you need a judge to help with the authenticity of it. And you don't obviously have access to all the witnesses who are going to offer testimony. So sometimes you have to hire actors. It's just, to me, unwieldy, as opposed to a jury focus group that can be much more controlled. You can deliver, as you say, a clopening of sorts, hit some of the highlights, and then control a dialogue and actually interact with the focus group participants to try to test theories, test damages, consider new themes, and focus groups can really help to guide how you develop litigation and defend the client. And the other thing I like about focus groups is there are so many different ways to focus group a case. You don't have to do a full-blown presentation, whether it be live or virtual. You could actually do it on paper, which is to say you could develop a script that's read to focus group participants virtually, like in a Zoom format, ask them questions, and they could submit feedback. And that can be done relatively inexpensively, say $10,000 to $15,000, and get valuable feedback as the case develops. And that can really help you to pivot and change direction depending on what those focus groups have to say.
It's a great resource, and you can scale it depending on what you're looking to accomplish, where you are in the litigation, and ultimately how big the potential exposure in a case would be. All right, so and we pretty much have covered that topic. So then to sort of summarize this portion, and then I'm going to spend just a couple of minutes talking to you about electric vehicles and autonomous and what's taking place in that space. Nuclear verdicts, as everyone who practices in litigation are on the rise. There are different strategies to mitigate those. But you really, as if you practice on the defense side of the docket, whether that's in-house or as outside counsel, it really requires you much earlier on to think, 18 months or 24 months down the road, is this the type of case that would have that potential exposure, and that you let those decisions that you make early on about the likelihood or not guide your preparation and your use of resources and which experts you hire and what jury consultant that you hire, so that the time to figure out, my goodness, this case has, high 8-figure or 9-figure exposure is not 75 days before trial. We'll just say it that way. Brad, anything else you want to talk about on this particular slide before we move to the last couple?
I think we hit the highlights.
Great. So then in closing, and I'll get you guys completed here right at 1 o'clock or a couple of minutes after. A couple of slides with regard to EV litigation continues to be an ever increasing sort of not only warranty claims, warranty litigation, if you happen to practice in California in particular, and also just standard litigation filings on either the vehicle, a property damage case, and you'll see a slide in a moment with regard to the ongoing issue of vehicle fires for EVs. But then also, and it's easy to overlook, in the wake of Loper, which was the United States Supreme Court case that basically now set aside fully Chevron deference to administrative agencies and instead relying much more on the major questions doctrine, that applies to NHTSA, and it applies to the type of rulemaking activity and frankly, NHTSA's position that existing FMVSS are all equally and concurrently applicable to an autonomous or, certainly an EV. In the space of autonomous, I think that's going to get challenged because that's not considered necessarily within the scope of NHTSA's purview from a regulatory standpoint based on how it was enacted. Moving forward, fires continue to be a problem. We see, I think, more property damage cases arising from fires, including some that are exceedingly expensive and high exposure than personal injury cases. But of course, and this has been the topic of any number of prior presentations by Dykema and others, the particular risks that are associated with an EV fire, not only trying to extinguish it, but keeping it from reigniting, the potential for explosion, toxic gas release, and then, how do you make sure that first responders are best in a position to be able to have knowledge of what to do if they're responding to an EV fire. Autonomous, fascinating space in the past year, still sorting itself out. The two things that I'd like to touch on here, crash incidents, whether that's in San Francisco or in Phoenix in particular. If it's an autonomous vehicle, it will get more news, and that obviously affects not only how the company whose autonomous vehicle it is, how they respond to it, but involves probably much more sort of PR and communication related teams or groups within the company than what would otherwise be the case if it's just an automobile accident. And then I want to hit this bottom bullet point here. One of our clients, Paul Nystrom in the Bloomfield Hills office, was retained by an autonomous company over the last 6 months to basically come up with strategies to help them combat the issues of vandalism and damage to their autonomous vehicles by members of the public who have bad intentions. And ultimately, that has turned into a litigation strategy where property damage, trespass types of claims are being brought against individuals who you can pretty much identify if they're attacking or doing some sort of really unseemly thing to your autonomous vehicle that they've ordered. And then when it shows up, they engage in vandalism because of all the cameras on the AV. And it makes identification of these perpetrators much more straightforward than they might otherwise think. And what the client has found is that in the process of doing this and bringing these claims in civil court, you end up with discovery that you can then hand over to a criminal prosecutor, and you're more likely to get a vandalism type of prosecution than you would otherwise be if authorities were having to go out and do all of that sort of work themselves. And then finally, in the ADAS space, advanced driver assistance systems, failure to equip claims continue to be ones that we see on a very regular basis, and then managing and helping, beginning with voir dire, juror expectations and their understanding of the technology and what it is intended to do, which is to assist drivers, not to replace drivers, becomes critically important by the time you close your case and get to jury argument. And then our closing slide on this point is most of our audience probably recognizes NHTSA did formalize and promulgate and publish FMVS 127 back in April of this year. The effective date is the model year for 2029, so 5 years out. Key things to pay attention to, or that we thought were particularly noteworthy at this point: the testing speed maximum of 50 miles an hour. In terms of the differential between the host vehicle and the target vehicle. However, the operating environment for both forward collision warning and automatic emergency braking is all the way up to 90 miles an hour, which is pretty dramatic. And then different types of test configurations, including those in low light or nighttime conditions. An emphasis on false activations, and I was just at client meetings this week. That continues to be one of the important internal OEM focuses, is how do we make sure we don't create an accident? How do we make sure that we are identifying circumstances where you could get a false activation and be going 75 miles an hour on Interstate 45 between Dallas and Houston, and all of a sudden your AEB activates for no reason. That is exactly what manufacturers are trying to further make sure that those scenarios are minimized to the greatest degree. But then notably, the rule as it's currently published would not allow for deactivation of those AEB controls. The consumer would not have the ability to turn them off. So we are 7 minutes over. I think we've covered our portion of the slides as well. Howard, we'll turn it back over to you and Rocky to close the webinar.
Thank you, Darren and Brad, and thank you to all those who joined us for today's Dykema Drives webinar. Please reach out. You'll receive our contact information after today's presentation wraps. Please reach out if you have any follow-up questions based on today's presentation to any of the panelists here or your relationship attorney here at Dykema. And look for the invitation for the next Dykema Drive series in your inbox soon. Thanks, everybody.
Thank you, everyone.
Thank you.